Hi, I'm Raees Mohamed, founding partner of R.M. Warner Law, and I wanted to talk to you today about an issue that is very, very near and dear to me. It's a significant part of my practice, and it's a problem that keeps me up at night. And that problem is being posted on a review site or a gripe site with false and defamatory information about you or your business. We receive a lot of inquiries at R.M. Warner Law about business professionals, attorneys, dentists, doctors, business owners, licensed contractors, professors, etc., who have been defamed on an internet platform and cannot get it taken down. Well, it turns out that we handle a lot of these kinds of cases, so I want to talk to you a little bit about how you deal with such a case and whether you can actually remove the false and defamatory review. So we've seen an increase in the number of inquiries with false and defamatory reviews. Why is that? The reason is actually pretty easy. You as a business owner are probably already listed on a directory somewhere on a review site and you don't even know it. For example, Yelp reviews already creates directories for every business. You don't really have a choice. You can't request to be taken down. You probably already have a directory listing. Same for Google reviews, Google Maps, and if you're a medical doctor, for example, WebMD. Again, it's simply a directory, but it also comes with the added benefit or detriment in our case of having the ability for someone to post a false and defamatory review. So the reason why there's an increase in this today has a lot to do with social media and accessibility of these sites. So what do you do if you're the victim of a false and defamatory review? Well, to answer that question really depends on what website you've been posted on, what gripe site, and what the facts of that defamatory review are. The first thing that I look at is to determine whether the review is actually defamatory or not. Unfortunately, there's nothing that you can do about a review that you don't like, but that's true. Truthful statements are not defamatory by definition, and there's nothing we can do about it. But there is something such as exaggeration and hyperbole, and that's sort of a middle ground. But the ones that we're really focusing on today are the damaging, false, and defamatory statements. Usually these are defamatory per se. That is, it's a false statement that accuses you of perhaps a crime, of being unchaste, of some sexual misconduct, having a venereal disease, being incompetent in your profession, etc. Those are most of the categories that in most jurisdictions are considered defamatory per se. So those are the best type of statements to look for. So for example, if you're a dentist and somebody has posted that you pulled the wrong tooth, it's definitely false. It also speaks to your incompetency as a dentist. That would be the type of statement that we would want to remove, and it's definitely a statement that is actionable. But even if you're not a licensed professional, if somebody's posted a review posing to be a patron of your product or service, certainly if they were never a customer, it's false. So anything that they would have to say regarding that service probably is going to be false as well, given that they were never a customer. So the bottom line is, what do you do? Well, first we look to determine whether we know who this poster is. Fortunately, and again, sometimes unfortunately, anonymous speech is protected by the First Amendment. We all like that. The problem is anonymous speech that is tortious, that is false and defamatory. There is no protection under the First Amendment for false and defamatory speech being an anonymous poster. So if you have a review and you don't know who the poster is, we have an additional step that we have to go through, and we'll talk about that additional step in a second. But let's assume for a minute that we know who the poster is. Well, the first thing I recommend clients to do is to contact us to reach out to that former customer and see if they're willing to at least cooperate and have it removed. You'd be surprised the number of inquiries we get where somebody literally just wants their money back or a portion of their money back, or perhaps even an apology. 99% of those types of problems can be resolved without any litigation. But then we have the more complicated review sites. For example, Ripoff Report, which is one of my favorite problems to deal with. And I say that favorite kind of begrudgingly, only because it's complicated for two reasons. Number one, if you're posted on Ripoff Report owns the review, which means, let's say Tom is a disgruntled business partner from John. Tom writes a post about John, and eventually they make up and they're friends again. Tom cannot voluntarily take down that post. Ripoff Report, according to their terms of service, are the copyright holder to any content that you publish. That includes images, includes text. I don't think that you can post videos on Ripoff Report yet, but anything you write, Ripoff Report owns it. So what are your options? And by the way, Ripoff Report is just one example, but there are numerous websites where once a poster has posted some content to the site, the poster no longer has control and they cannot voluntarily delete it. So focusing on these type of sites, what are your options? Well, it turns out Ripoff Report has two avenues to take down or redact, in the case of Ripoff Report, defamatory content. The first thing is arbitration. Common question that we get is, hey, if a platform offers arbitration of some sort, isn't that considered extortion or blackmail? You basically have to pay this website to conduct their own private arbitration or dispute resolution process, and they take it down? And the answer to that question is, it's absolutely not extortion. It's absolutely lawful. By signing the terms of service, the poster has agreed to whatever contractual arbitration process that is stated on the site. So if you have been defamed on Ripoff Report or any other site that has a process like that, usually your first step is to review that process with an attorney to figure out, do you have a better chance of getting the content taken down through that arbitration or alternative dispute process? Ripoff Report's arbitration process is actually one of the better, more developed processes, and that's not advocating for Ripoff Report at all, but it just is. They usually use an actual retired judge or arbiter, and they pay them for independent opinions on the actual statements that were posted. What does that mean? So you get an opportunity, again, through a long process, a formal process, where you can present evidence on why the statement is false. And the person who posted it, anonymous or not, has to respond within a certain number of days, just like in court. The benefit of this arbitration process is it's much, much faster than litigation. It's usually somewhere between 45 to 60 days. Perhaps a little bit longer if Ripoff Report can't get an arbitration opinion in final order within the 60 days. But usually it's within 3 months you can get a ruling. At R.M. Warner, we've had a significant amount of success getting statements redacted through the arbitration process. And why do I say redacted? I say redacted because Ripoff Report will not remove your content. Let me repeat that. Ripoff Report will not remove content even if it is false and defamatory. And you're going to ask, why is that? Well, there are a lot of reasons why a content platform wouldn't take down the content. Perhaps it's generating traffic. But the remedy you get through the arbitration is redaction. The second possibility with Ripoff Report that we've done at R.M. Warner Law is litigation and getting a court order that states that specific statements are false and defamatory. In the cases where we use litigation to get a statement taken down or pursue damages, Ripoff Report will not act unless it has a court order specifically delineating the statements that were false as such. Once they have that court order, they generally, through their terms of service, will honor such court orders if they meet other specific requirements of Ripoff Report. Now, as a website, they generally change their policies, but for the most part, you have to make sure that the court order identifies each and every statement that is false and defamatory, and it has to be a finding of fact. Default judgments just don't work with Ripoff Report. They may work with other sites, but not for Ripoff Report. So one item I should mention is Ripoff Report's arbitration process does not allow you to get damages against the poster. So if you're looking at your two options, again, depending on what the objectives are of the client, we're going to determine whether litigation in a traditional path makes more sense or pursuing arbitration for hopefully what we anticipate to be a quicker route to get a statement redacted makes more sense. So assuming you've been posted on one of these gripe sites, we talked a lot about Ripoff Report. The bottom line is this. I know how you feel. It's emotionally devastating to have something out on a website that's a blatant lie, particularly if you're a licensed professional like a doctor, dentist, or lawyer, or contractor. Have it hanging out there even for a few hours. You can imagine days. But in some instances, we have clients that are out there for months at a time before we can get any resolution. And typically that's because courts just aren't fast enough, particularly if there's an adverse party that's litigating to keep the statement up. So that's definitely one of the challenges with getting statements taken down from some of the review sites. Another challenge, which we skipped over earlier, was what do we do with anonymous posters? Anonymous posters are a long discussion, but the bottom line is we can use the subpoena power to try to compel websites and IP issuers and internet carriers to produce the information, what we call subscriber information. of an anonymous poster. We do have to meet legal requirements. In Arizona, that's the Mob Lisa case. We have to show that we can prevail on summary judgment with all the information other than the identity of the poster. Not always an easy task, but just remember that anytime you have an anonymous post. But bottom line today is I really want to underscore the fact that the emotional turmoil, damages, and what else you're suffering from as a poster is something that we're familiar with at RM Warner. It's something that we can try to get recourse for you for. There's no guarantee at the end of the day. To make matters worse, it's the internet. Things go viral. Sometimes we even have websites that do re-indexing of other people's content. So that means that once something is posted out there and you get it down from the primary site, it's possible that there was a crawl website that grabbed the content and will replicate it later. In those cases, even with the judgment, it could take months and months and months of pursuing to get taken down. But nevertheless, we're definitely familiar with the issue. And I'd like to underscore that it's very important that you have competent counsel who's experienced in tackling defamatory online reviews to get you recourse that you need. If you have further questions on this issue, feel free to reach out to us at RM Warner Law.